Hi everyone, welcome. So today we are doing our Q&A. So if you have questions, you're joining me live, go ahead and put it in the comments. If you are watching this on the replay and you have questions, go ahead and put it in the comments as well. I do go back and look at those, and sometimes if it's good, if it's a good question, I turn it into a video. So this is Immigration Q&A with me. I am U.S. Immigration Attorney Lilian, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. Hi, Mary. Thank you for joining me. Feel free to say hi in the comments and let me know where you're joining me from. And like I said, if you have questions, please put them in the comments. I do have questions that people send ahead of time, so I will be responding to those. Hi, Barhane. I hope I said your name right. Hi, welcome. Um, and yeah, so Atlanta, nice. I have family out there, so that's nice. And Mary's in Alabama. Wow. Welcome. If you have questions, immigration questions, please put them in the comments. Like I said, I do have questions that I received ahead of time, so I'll be answering those. But if you're joining me live, you get to get your answers now. Okay? You get to have your questions answered live. Um, and if you're usually joining me on Facebook, I am really sorry, but for some reason, the Facebook is just not working today. But we're on YouTube and on Instagram, so switch over there. All right. So the first question I have is from an update I did, and someone wanted to know what is the number to call USCIS when you want to get an update on your VAWA case or your U visa case or your T visa case, because now you can actually call USCIS and get that information before you had to send mail to USCIS. So it is literally their USCIS hotline number. Okay. There's no new number. There's nothing different. It's just the USCIS hotline number, which is 800-375-5283. Okay. That's the number to reach USCIS. Sometimes you can get someone on the phone depending on what you need, and sometimes you can't. But that is the number to reach them at. All right. So perfect. So we have a question from Instagram, not just a writer, asks, I'm in a group I help with. In a group I help with, there are students having trouble joining the military because of status. Any thoughts on this process? So before, like many years ago, you could have joined the military without having any status in the US. However, they have changed that a lot. And now you need some form of status in order to then be able to join the military. Usually, they want a green card, they want permanent residency before you can join. And also with that, the benefit of that is if the person already has a permanent residency to join, then they can immediately become citizens as well. So, but you know, as far as joining the military, they do have those status requirements. I would say have the students reach out, do a consultation, because we want to know what status they currently have and if there is another status they can go to that will make it possible for them to join. Because sometimes the military will tell you the status that they need the person to have as well. So that may be the best way to go, is just to figure out where they are at right now, where they need to go, and how we can bridge that gap. All right. So remember, if you're joining me and you have questions, put them in the comments. Bahene has a question. I brought my girlfriend from Nicaragua on the parolee authorization program. How can I get her a green card? Marriage is not an option right now. She doesn't want to do asylum. Ooh, okay. So those are going to be hard options for her. Um, so when you come in with the parole program, you are expected to eventually figure out a form of another way to get status, because that parole program lasts for 2 years. So you're expected to either apply for asylum if you qualify, or another family based option. If there are no family based options, maybe look into employment based options. And also, depending on her, everything depends on the individual. So I typically suggest doing a strategy session to figure out what she can actually qualify for, because I have a lot of questions. Right? I have a lot of questions already. So there may be other options available to her, like a U visa if she's ever been a victim of a crime. There's specific crimes that if she's ever been a victim of in the US, she may be able to eventually get a green card through. It's a longer process, but that may be an option. If she absolutely doesn't want to do asylum, um, I would still do a consult on asylum to see if she does qualify, because sometimes people don't want to apply for asylum but they qualify, so we usually talk about that as well. But yeah, it really is going to depend on her particular situation. So my suggestion is schedule a strategy session with me so that we can see if she qualifies for something and how we can go about getting her that, especially since you already said that marriage and asylum is not something she wants to pursue. All right, so Mary got approved. So she got her advanced parole approved. Can she travel while the U visa is pending? I have a bona fide determination. Congratulations. Yes, because you have the advanced parole, you can travel without stopping your U visa case. That's the point of the advanced parole, because sometimes people think because they have a U visa pending, they can just leave the US and come back. But with the advanced parole, that gives you the permission to come back. So that's the key. So with the advanced parole, again, I always have to put a caveat on top of advanced parole. If you have any criminal cases or things that may cause an issue with the officers at the airport, you may want to just get a consult on that before you leave on the advanced parole. But typically, if you do not have any negative immigration or criminal history, you would be able to leave and come back. And when I say negative immigration history, overstaying a visa is not negative immigration history for this purpose. Okay. The advanced parole was created for people that either have overstayed their visa or entered without authorization to be able to leave the US and come back. So don't think that that's a negative immigration history, okay? All right. Yeah. Congratulations, Mary. You should be able to travel and be able to come back. The only thing with those is, depending on where you're traveling to, just make sure your passport can take you there, because the advanced parole only allows you to come back to the US. It does not give you access to other countries. All right. Can she travel? Oh, additional question on the asylum. Can someone that apply for asylum travel back? Well, if you are filing asylum from a country, it is generally assumed that you will not be going back to that country. If you feel safe enough to travel back to that country, then USCIS, the immigration court, is going to question whether you are truly in fear for your life in that country. So typically, when you have an asylum pending or an asylum approved, we do not recommend traveling to the home country that you are seeking asylum from or that you received asylum from. Once you are a citizen of the United States, that is a totally different situation. You would be able to travel without that affecting your ability to keep your citizenship. However, traveling while on either asylum pending or asylum approved or green card based on asylum. All those things can affect your ability to keep your status in the US if you travel back to your home country, unless you have a really, really, really good reason that an officer believes is good enough to allow you to go and come back. All right. So if you have any other questions, go ahead and put them in the comments. Like I said, while I'm waiting for your questions, I am going to address some of the ones that I received ahead of time. All right. So this question was from a video that I did on petitioning for a parent that entered the US without a visa. So this person asks, my mom entered illegally in 1985, she left back in 2011. She hasn't been back in more than 10 years. Can I bring her with the I-130? Great question. So typically when you're in the US for more than a year and you leave without any immigration permission to leave and come back, you trigger a 10-year bar, meaning you cannot get a visa to the US, you cannot get anything to the US until that 10 years has passed. Okay. So for this person to file for their parent, the 10 years has already passed, which means the mother now has the opportunity to get a green card and get a visa to the US through their child. So when I tell people that, sometimes you need a waiver, sometimes you don't need a waiver, right? When you come into the US without authorization and you leave and you want to immediately apply, you may need a waiver, but if you are waiting 10 years outside of the US, you're not going to need a waiver, all right? You're not going to need a waiver, especially if you only entered one time and overstayed and then left, all right? So that's really the key here, is that this person only entered one time. If you enter multiple times and stay for more than a year each time, you're going to have something called a permanent bar, not just a 10-year bar, but a permanent bar. With the permanent bar, you must be outside of the US for 10 years. There's no waiver to shorten that 10-year period. Okay? You must be outside of the US for that 10 years. And you need to apply for a waiver to allow you to apply for a visa, even if it's through family. So it really matters how many entries the person has had in the US. So if it's one time and then they stayed outside for 10 years, they can apply through a child. If it's multiple times and they overstayed like a year or more each time, they may have a permanent bar that will then restrict their ability to file for the visa without a waiver. All right. So, Berhani is asking how much do I charge for a consultation? So we have two levels for our consultation. We do a strategy session, which is a 15-minute free session where I basically get information about the person, see if we can help, and determine if we need a deeper consultation where I would review, filings and things like that. But if there's no need for a deeper consultation, then we do the strategy session, figure out if I can help and what that would look like. And then if there is a need for a deeper consultation, those are 200. But like I said, we start with that 15-minute session to just make sure that I can actually help you before we get to a deeper consultation or get to working together. So typically in the 15-minute, we're able to figure out what the next steps are going to be. And for people that just want a full, deep consultation with, bring me all your documents and all of those things, you can also schedule that. Like I said, it's 200 to schedule those. Okay, so to do a consultation with me, you can do one of two things. You can call my office at 508-443-1788, or you can go to my website, lilylegal.com, and click on contact us. And you can actually, right on my website, pick a date and time for a strategy session. Okay, so those are the best ways to schedule that. All right. So I see a question here. My I-130 was approved a month ago, but my I-485 isn't approved. How long do you think it can get? Okay. How long do I think it will take before it gets approved? It's almost 60 months since I applied. Okay. So first, you need to look at the processing time for your area, because that's what it's really going to depend on. So, yes, the I-130 was approved. I guess my question would be, did you have an interview or not? If you did not have an interview for the I-130, it does happen sometimes. I've had cases where the I-130 was approved, but they may have had questions they needed to ask for the green card application, and they're just waiting to schedule an interview. And that's just what they're going through right now. If you already had an interview, which I see you already had an interview, you may need to do what we typically do would be a service request with USCIS, just to see, what's going on here. Is there something you need? Is there something, excuse me, is there something that we need to do to get things back on track? But that's what typically, if it's been 60 months since the filing or since the interview, a strategy, I'm sorry, a service request may be the best thing to do, so that you are able to see if there is something USCIS is missing. Typically, when people come to me with this, we I do a full strategy session where we talk about what could potentially be the issue, right? We talk about immigration history. We talk about, how the person came to the US. We look at, affidavit of support. We look at everything to determine, is there something here? Is there something in your history that could have led to a delay in the green card application itself being approved when the I-130 was already approved? So the I-130 is just, the marriage. The green card application, the I-485, is you, the immigrant looking to get the green card. That's what it focuses on. So that's why I say, when it comes to that, it really matters about your specific situation, your specific history, to know if there is something in your background that could have triggered a deeper look in your case. Or sometimes they do. Um, Sometimes the offices have questions that they just haven't found the answers to, so they hold on to the case until they do. Okay, and sometimes it's absolutely nothing. They just haven't gotten to it yet. Okay, sometimes things fall through the cracks, and we have to do a service request to kind of get it unstuck. All right. So if you have additional questions, please feel free to put them in the comments. All right. Okay, so this person asks, so they were documentarily qualified. So basically, let me set the scene. They did an I-130. The I-130 was approved. It was sent over to the National Visa Center. They did all the things that the National Visa Center wanted them to do. And the National Visa Center came back and said, hey, we have all your documents. We have everything we need. We'll let you know when we have an interview date for you from the embassy. So that's what it means to be documentarily qualified. So this person was documentarily qualified in January of 2024. And they want to know, how can they find out the waiting list for interviews in Liberia? And will this affect their priority date of May 2022? So, your priority date and your documentarily qualified date are two separate things. All right. Completely separate things. When you're documentarily qualified, you are now officially in line for an interview. Your priority date tells the embassy, yes, this person's priority date is current, so you can actually give them the visa. Okay. The priority date just tells the embassy, yes, they can get this visa today. Documentarily qualified means, hey, I can officially get in line for an interview. So sometimes someone with a later priority date, so this person is on May 2022, someone with a priority date of, let's say, May 2023 may end up in front of her in line for an interview because they completed the documents section with the MVC faster. So your priority date does not bump you ahead of someone that completed their documents and their requirements faster than you. Okay. Now, can you find out what the waiting list is? No. Unfortunately, no. The embassy does not publish those. Okay. That's really the biggest issue. With USCIS, we can at least get some form of priority, processing time, right? With USCIS, we can get some form of processing time, but with the embassies, we don't actually know. They don't publish those unless you're like doing a non-immigrant visa. So if you're doing a B2 visa, you can kind of get an idea with the embassy on how long they're taking for those. But when it comes to family-based, they do not publish those. There's no way to go and look at those. So that's why I always tell people, once you reach that MVC stage, get your stuff done as quickly as humanly possible so that you can get in line for an interview. I still have people that have been waiting for an interview well before COVID. Okay. So in some places like Liberia, for example, if you do a fiance visa for Liberia, I can tell you right now that they are not scheduling those interviews. They are not even allowing the National Visa Center to send them the file because they don't have the capacity to schedule those interviews right now. So it is taking longer in some places than other places. So you really just need to be patient when it comes to the embassy. And no, it's not just you. It's not you. You're in line for an interview. And once you get there, you'll get there. Okay. All right. Bahrain is asking, is there a limit to how many people you can bring through the Nicaragua parole program, trying to also bring her sister? No, there's no limit. It's really just about your income. So as long as your income meets the requirements and is enough to sponsor multiple people, you can sponsor multiple people. USCIS will let you know when you hit a limit when it comes to your income, but as long as you haven't hit that limit, you can sponsor more people. Kasmida, hi, happy weekend. Thanks for joining me. All right. How many times can I use advanced parole to enter the US? So it depends. When you filed, as long as you selected multiple entries, it should have an expiration date on it, right? So just make sure that you're not outside of the US on that expiration date. But yeah, multiple times. There's no limit, just not extended periods of time. That's the only thing I will tell people when it comes to advanced parole. It's really for short trips, like a month is pushing it with advanced parole. So just make sure you're not staying out of the US too long. But there's no like, this is how many times you can use this. Okay, as long as you apply for the multiple and it doesn't say just one trip, you're fine. All right. Question from Instagram, please. I filled N400, so that I have filed all taxes, but I have a payment scheduled for 2022 tax return. Would that hurt my and 400 interview. So as long as you have a payment plan, so when you're applying for citizenship, it's going to ask you if you owe any taxes. And if you do, you just say yes, but just bring documentation showing that you actually have a payment in place, right? That you have a payment plan and that you're following through with that payment plan. That's what the officer wants to see, right? If you're saying that you owe taxes, but you do not have a payment plan, please go get a payment plan and start making payments on that. But as long as you have, that payment plan in place and you bring documentation of it and you bring proof that you've been paying. So sometimes people will just print out the payment plan agreement and think that's enough. It's not. It's not enough. The officer wants to also see that you are sticking to that payment plan, whatever it is. Okay. So just make sure that you bring that, and that's all they need, honestly. They just want to make sure that if you owe the government, that you're taking steps to pay the government, right? That's all it's really about, that you're taking steps to do that. So make sure that you are documenting that. All right. So, Brahim, I have not heard that, but what I will do, because, I don't know everything. I know a lot when it comes to immigration, but I don't know everything. So if that has changed, I will, after this video, if it has changed, I'll just do a comment on this video, just letting you know what the status of that is. Okay. But have not heard that, but I will update you once I have that confirmed or not confirmed. All right. All right. So remember, if you have questions, you're joining me live, ask your questions. That's what I'm here for, to make sure that you are getting your questions answered and that you are getting up-to-date immigration information, okay? So I did a recent video. We posted a recent video about whether a USCIS officer can look at your phone during your immigration interview. And someone asked, are they allowed to look at the American citizen born phone, or is it just the one applying? Well, in that video, I talked about how USCIS offices don't generally ask you to see your phone unless you say that there's, information relevant to your case on your phone, right? If you say that you have pictures on your phone, they can ask to see the phone. Okay. So if it's the US citizen that says they have that information on their phone, then yes, they can see the phone. Whether it's you or the person you're filing for, you are both applying for something. Okay. So let's say it's a marriage based case and the wife is a US citizen and the husband is the one trying to get a green card. The wife is applying for an I-130, right? The wife is the petitioner for the I-130. You're the one trying to prove that your marriage is real. So, yes, even though you're not the one trying to get a green card, the petitioner still has the burden of proof to USCIS that this marriage is real and you two plan on building a life together. So yes, USCIS can look at both phones if you tell them that there's relevant information on the phones. They don't generally have you walk into the room and say, let me see your phone. That's not that's not how it typically works. But if you tell them that there's relevant information on your phone, they can ask to see it, whether you're a US citizen or not. All right. Okay, so, great question. So when you are calling USCIS, you have to be either, depend on the form you're calling about, right? That's what it depends on. So even though So this person is asking, do I have to call USCIS myself or my wife, the petitioner, about the I-485 application, which isn't approved yet? So the I-130, your wife is the petitioner of the I-130, and that's it. The I-485, you are the applicants. So your wife cannot call about the I-485. They can only call up I-130 that they are the petitioner on. So as the applicant for the I-485, you have to call and get the information from USCIS, not your wife. Okay, they wouldn't even give her the information on the I-485. Just like if you called asking for information on the I-130, they wouldn't give it to you either. All right. Question from John. Can a green card holder file for the sister who is over 21 years old? No, a green card holder cannot file for siblings. Does not matter their age. Only US citizens can. All right. So green card holders can file for their children that are unmarried, regardless of their age. As long as they're unmarried, a green card holder can file for that child. They can file for their spouse, and that's it. Okay, those are the only two group of people that a green card holder can file for: their spouse and their children that are unmarried. Beyond that, you just have to wait till you're a citizen, then the world opens up more, right? Once you're a citizen, you can file for siblings, you can file for parents, you can file for a fiance, and you can file for married children. But as a green card holder, you are limited on who you can file for. And that's a great question because I get that all the time. I get people that ask me about, who they can file for and all of that all the time because they're getting pressure from family asking them, oh, by the way, now that you're a green card holder, now that you have status, file for me too. And I have to tell them, well, you can't, right? And sometimes they're like, oh, can I add this family member to the call so that you can tell them that? And it's not just coming from me. And it's always hilarious. But yes. Another question is, okay, if you're in AOS process, can you travel outside the US? You can if you have advanced parole approved. Okay, so when you filed your adjustment of status, if you included an application for advanced parole, so a travel document, you would, and that travel document has been approved, right? So once you have that advanced parole approved and you have that approval in your hand, then yes, you can travel outside of the US. But if you do not have advanced parole and you travel outside of the US, your adjustment of status will be considered abandoned, which means it will be canceled. You no longer have an adjustment of status pending. Okay, so just make sure if you don't already have an advanced parole travel document pending with USCIS to file that, especially if you want to travel outside of the US while your green card application is pending. And if there's an emergency reason that you need to leave the US sooner than that, sooner than the advanced parole gets approved, you can apply for emergency advanced parole. You can ask for an expedite of the advanced parole. Depending on the emergency, USCIS will then decide whether to expedite it and get that approval to you faster. Okay, but yeah, definitely do not travel without advanced parole. Please, please, please. Because I have seen that ruin quite a few people's ability to get a green card. Can a person who is in the USA on a B1, B2 visa from Tanzania, can she file for asylum? Anyone in the US that has that meets the requirements for asylum cannot file for asylum, right? So it just depends on their reason for seeking asylum. right? Asylum is based on persecution. So if the person was persecuted on a protected grounds, then they would qualify for asylum. They have to, prove the persecution. However, it's not really a matter of where the person is from. It's more of what the persecution is, and if it rises to the level where they can qualify for asylum. Okay, but no matter what country you're from, you may qualify for asylum in the US. Okay. It just depends on your particular situation. All right. Good questions, John. Good questions. All right. Oh, and I should mention, now that I think about it, if the person enters the US with a B1, B2 visa and they want to apply for asylum, they should generally apply for asylum within 1 year of entering the US. If they apply after 1 year, it's going to be a little bit more difficult to get asylum, because they will now have to prove why they didn't apply within that 1 year. And hopefully, an officer or an immigration judge would agree to waive that 1 year requirement, but there is a 1 year requirement from the time you enter the US to apply for asylum. Just wanted to mention that. All right. And I know I always forget to say this, but if you're joining me and you're enjoying this program, this immigration Q&A, please go ahead and hit the like button. And if you are not already subscribed, go ahead and subscribe so that you do not miss any of my uploads. Like I always say, I do go live almost every Friday. I've been taking like a Friday off a month just to recoup. But yeah, you can join me live and hear immigration updates. We do our Q&A the last Fridays of the month, and we also I do like a teaching Friday. So definitely come with your questions and learn some immigration law. And sometimes your questions is going to help someone else. So I always say, ask your questions. It may help someone else. How many days does adjustment of status take if you do premium processing? If you're doing adjustment of status based on family, right? If it's a family based adjustment of status, there is no premium processing. I There should be, but not. So if you're doing a family based adjustment of status, there is no premium processing. Employment based, yeah. Premium processing in general is more on the employment base, student change of status, end of things, not adjustment of status. Okay, so yeah. So premium processing typically they say 2 business weeks. So that's what they typically say, 2 business weeks, unless they need unless it's like a request for evidence that will delay the process of them making a decision, but they typically will process things much faster with premium processing than they do with family based. Is applying for adjustment of status an option for a Nicaraguan parolee if they were paroled into the U.S. under the parole program? Then yes. Okay, they can adjust status based on something, right? They can't go from parolee to adjustment of status without something else in the middle, right? So if let's say they get married, or depending on the situation, if they qualify for an employment based adjustment of status, they can do that. But they can adjust status, they just need some reason to adjust status, if that makes sense. So employment based or family based, or if they qualify for like asylum and they get asylum, they can apply for adjustment of status through that. So Yes, they can adjust their status. They just need a basis to adjust their status. All right. Any other questions, please feel free to ask me. Like I said, these Q&As are literally for you all to ask me questions, to get information. And if you're watching this and you're like, I need to speak with Lily. I need more information. I need to see if I qualify. You can definitely schedule a strategy session with me by going to my website, lilylegal.com, and just clicking on the contact us, and you'll be able to pick a date and time that works for you to speak with me. You can also call my office at 508-443-1788. The strategy sessions are just a free time for us to talk and get more information about your situation, my situation, and see if we can work together. Okay, that's really what it comes down to. When it comes to immigration law, it's not one size fits all, even though, you know, wouldn't that be nice if everyone's situation is the same and we can just make things work that way? But no, when it comes to this, everyone's situation is different. And yes, I can answer basic questions here, but I can't really get into your particular situation to give you actual legal advice that you can use to adjust your status, to change your status, to get status. So definitely feel free to schedule that strategy session. Like I said, it's a free 15-minute for us to talk and see what you qualify for, what we can do for you, and the best way for you to move forward. All right. How long does it take someone to apply for asylum up to approval? Ooh, okay. That's John, that is a great question. And the answer to that question is it depends. And I am so sorry that I have to give you that lawyer answer. But a typical asylum case can go anywhere from a few months to a few years. And that's just the reality of it. If the person is going through immigration court and they're not detained, it's going to be at least a year or more to have a final hearing in immigration court and then have a judge decide on the asylum. If they're going through USCIS, it is going to take way longer. Okay. I have cases from 2017 that we're still waiting on interviews for. Okay. So this is something that asylum is one of those things. It just depends on where you are in the process. Some asylum offices are taking, the first cases that were filed are the ones getting interviews quicker, and some are doing the last in, first out. So basically, if you file today, you have a better chance of getting an interview than someone that filed 5 years ago. And I am so sorry to say that, but that is the truth. But then again, I have ones that we filed a year ago and we're still waiting for an interview. So it just really depends on the office, the asylum office, how many offices they have, and how overworked they are. Some asylum offices have more asylum officers and are able to do more interviews. Asylum cases, their interviews take more time and more mental space for an officer to conduct it. Like an asylum interview can go anywhere from 30 minutes to several hours. Okay. And they have to do those. They have to go for as long as it takes to get all the information they need to make a decision on the case. Okay. And there's not a lot of asylum officers because you really have to be, they go through people quickly because hearing people's asylum stories can be traumatic to people, right? It can be traumatic to the officers. So they can only do so many a day, and they run through people quickly because, again, secondhand trauma is a thing. And it's just, It just takes too long. But yes, asylum cases take way longer than it should. Um, and there's a huge backlog. Only ways to move them quickly is if there's a reason to expedite, which is, for example, if there is an immediate threat to life, that would be a reason to expedite. You would need to present evidence of that, and then USCIS will decide whether to expedite or not. Most asylum offices have a short list that you can ask to be included on. I can tell you right now, my local asylum office in Boston has like 35,000 people on their short list. So the short list is no longer short. Okay. So that's also an opportunity that can lead to your case being processed faster. If you're on a short list and let's say they realize that they have to cancel another interview, they can call you the day before or a couple days before and say, hey, we have this interview open. Are you able to come in? Yes or no? And if you say no, they'll just go to the next person on the short list. So, but that doesn't take you off the short list either. But it's just, those are the only two ways to really get those moving. All right, let's see. What is the fastest route to bring my 13-year-old daughter to America from Ghana, a green card holder? Well, only route your only realistic route is to file an I-130 for the child and go through the embassy. If there is a reason to expedite on either of those, and so either expediting the I-130 or expediting the visa interview, those will be the fastest, because if you're able to get the I-130 expedited, it will be a shorter waiting time to get to the embassy stage. And then if you're already at the embassy stage and you want to get your interview expedited, it will be a shorter waiting time as well. But that unfortunately is the only route. I know some people look at the B1, B2 visa, but as a green card holder, the chances of that being approved for a 13-year-old, right? Because remember, the B1, B2 visa is for someone that's just coming to the US on a temporary basis and is planning to go back. And they have to show that they have enough going on for them in their home country that they are going to go back. All right. It's hard for a 13-year-old to prove that's coming to see their parents in the US and that parent has status. It's hard for a 13-year-old to prove that they will be going back. So that's just why I say that the realistic option is to do that I-130 and then the visa through the embassy. If someone is in the US in F1 visa status for 1 year, can he or she stay up to the time he or she finishes his studies, or he needs to go for visa extension every year? So the F1 visa itself allows you to come to the US, and if that visa is still valid, you can travel back and forth. But once you're in the US, you are in F1 status, and it's usually DS, which is duration of status. So as long as you maintain your actual F1 status, you can stay in the US. If you do need to travel outside of the US after that F1 visa expires, you will need a visa to come back to the US. So you'll need to go through the embassy to extend that visa. But you do not need to leave every single year. It's just, if you leave the US and your visa is already expired, you need to go through the embassy to get a new one. All right. But it just depends. Okay. If you're just going to stay in the US and have no intentions to travel, then you don't have to leave every single year to get that visa extension. There is exceptions for Canada and Mexico. If you're there for less than 30 days, you wouldn't need a visa to come back to the US. But if you're going to be gone more than 30 days in Mexico or Canada, you need that visa to come back in. And don't do the thing where people go to Canada for a day, travel to another country, and think they're going to come back. Guess what? They look at your passport to see where you've been. Okay. So that also matters. All right. So if you have any questions, please don't forget to put them in the comments. If you're watching this on the replay and you have questions, put them in the comments. I do go back and respond to those questions because, again, the point of these is for you to get information. So I take it very seriously when people ask me questions. And like I said before, if you are trying to figure out if you qualify for something, if you should start the process, how to start the process, and want to speak with me and see if we can help you out with the process, you can do that by going to my website, lilylegal.com, or calling my office at 508-443-1788. These are free 15-minute strategy sessions to just see where you're at and if and how I can help you. So, okay. So if you finish your study and you go back to your country, can you apply for a visa and they won't treat you that you overstayed in your F1 visa? So if you leave after finishing your studies, okay? So if you don't overstay your status, that's really the key here. So when it comes to F1 and you have that duration of status, unless when you came into the US, your I-94 says anything other than DS, so it should say D/S, either on the stamp in your passport on your or on your I-94. If it has a date, then you need to leave by that date. But typically for an F1 student, it will have a DS, and that is not, as long as you can show that you maintained your F1 status, that is not treated as an overstay. So for example, if you are on a 4-year program, you finish your program, you do OPT after your program, and then after the OPT, you leave the US, let's say like a week or two after your OPT, you're fine. That is not considered an overstay. Okay. It is not considered an overstay because you maintained your status. That's why it says duration of status and doesn't have a specific date for you to leave the US. So someone that is on F1 doing a 4-year program, once they're done with their 4-year program, they can choose to do a master's degree, right? And continue on their F1 status. That's still considered duration of status. And then they can decide to get a PhD, still considered duration of status. And then after their PhD, if they're like, don't really want to stay in the US and look for a job, or I'm not able to get a job here that will lead to a green card or another status, and I want to leave, they can leave, and that will not be treated as an overstay, because they maintain their status that whole time. That's what they care about. Did you maintain your status the whole time? And part of maintaining your status is not working unless you have authorization, right? You can work on campus, or if you want to work off campus, you need authorization from the school and from USCIS. If you want to work after you finish your degree and do OPT, you have to go through your school and your and USCIS to get that work permit. So it's really just dependent on your how well you maintain your status. So maintaining your status is the key with everything. When it comes to F1, maintaining your status is the key to be able to change your status to something else as well. So even if you stay in the US and you want to change your status to, let's say, an H-1B, because you have an employer that wants to file for you, if you didn't maintain your F1 status, if you did not maintain your F1 status, you cannot change status to H-1B or something else, okay? So it's really just maintaining that status throughout. And sometimes people fall out of status with the F1, and we're able to get their F1 status reinstated. So we had to do that for a family that fell out of status and get them back on track with their F1. So it's really just about maintaining the status at all times. All right. Pierre on Instagram said, we need to talk. I'm happy to talk. Like I said, going to my website, lilylegal.com, and then clicking on contact us is the best way to do that. You can pick a date and time that works best for you. And we can talk about your immigration journey, about what you need, and the best way to assist you with the process. Okay. And like I said before, that is a free 15-minute strategy session. And then we can decide from there if there needs to be a deeper consultation. And those more detailed consultations are $200. I try to be as transparent as possible when it comes to those, so that you know what you're getting yourself into. All right. So, God's favorite. Do you qualify for VAWA if your spouse was arrested and released but didn't disclose to you um, till he got rearrested and put on house arrest for the past 2 years and he's still not opening up? Ooh, it depends, right? So, VAWA is based on battery or extreme cruelty. Okay, those are the two things you need to prove. Either that you were, battery is basically physical abuse, and extreme cruelty is everything else. Okay, so battery, physical abuse, extreme cruelty, everything else. So it just depends on the details, what else is going on. Typically for VAWA cases, we do like a deep consultation where we talk about every single thing that's gone on, because some things you may not even consider part of the abuse that happened. And sometimes I have people go ahead and do a psychological evaluation, because again, I am not a psychologist. I am not trained to help people through certain things, right? I am an immigration lawyer. I am about helping victims of abuse get immigration status. However, I try to do that in the most, how do I put it? In the most effective way that does not lead to the person being re victimized, right? And working with a psychologist is the best way to do that, because sometimes the things that you have been through, talking about it can trigger some things in you that can lead to more psychological trauma than I want to put you through. So sometimes we have our clients go through a psychological evaluation just to talk about all the things that have went on, and the psychologist is more equipped to pull um, on those strings and get more information and support you while you're doing that. Okay. But if it's just that, arrest alone and release alone may not be enough to show extreme cruelty, but typically there's more to it than that. And you want to kind of explore all those other things. All right. Also, can you file for VAWA while your I-130 and I-485 is pending? Yes, definitely can. And we've done that at my office as well. We typically will have the I-485 put on hold by USCIS and make sure that a decision is not made on it based on the I-130, but based on the VAWA application. And that is good for my clients because, well, before April 1st, they would have had to pay for the I-485 again on the VAWA, unless we put that I-485 on hold with the I-130. But now there's no additional fee for the I-485 for VAWA cases. So we can always choose whether to just withdraw the I-485 or leave that alone and move forward with the VAWA application still with a different at 485 for the VAWA. So it just, again, it depends on each person's situation and what would be the best. Typically, if the, and I remember, God's favor, I think I remember you asking a question last week or the week before that. My weeks blend sometimes, but I think I remember your previous questions. Um, but yeah, if the I-130 is being like paused by USCIS based on spouse situation, um, it may just be best to put that on hold and do the VAWA if you qualify for VAWA, right? Um, VAWA is not just like I said. I have a special place for VAWA applications and VAWA applicants, so we definitely try to confirm that that you qualify and then work with you to put together a strong application. And Bahrain, thanks for taking action. Okay, they already scheduled a session with me. Thank you for taking action. Sometimes it just, I have to remind people that they can take that action and schedule that strategy session with me, so that you're not waiting. And sometimes we do get filled up. So you want to go ahead and schedule that so that you're getting the best date and time that works for you. So if you're on Instagram, I am just putting the contact information in the chat. And then I'll also put that in YouTube. Don't worry. Don't worry, my YouTube people. I'm coming. Someone asked very specifically, so I want to make sure that I am putting those in. And then all right. So, question: they keep denying me because I have a misdemeanor for driving with no license. Everything is paid off. So why are they still denying me my TPS? All right. I will need you to schedule a strategy session because I need to look at the court disposition for that misdemeanor, and the denial. So typically they will tell you the reasons in the denial notice, or if they send you a notice of intent to deny or a request for evidence, they will put more reasoning in those. So yeah, schedule that strategy session. It will give me more information so that I'll be able to actually properly advise you. So without documentation, it depends is the answer, is the best answer I can give you. All right. Yes, that was me. Yeah, God's favored. It of course it will be concerning. So definitely I suggest reaching out. Let's see what the status is. And see if you qualify for VAWA, and you can always go that route. Okay. Amber Haney. I'm just going to put this up here because thank you for saying it. I am so glad. I am so glad that you are getting information that is helpful from my channel. And that's really the point here, right? The point is to make sure you're getting information and then making the decisions, taking the next steps when it's necessary and when you need it. Okay. Like I said, on here, I can give you general information. I can't really dive deep into your personal things. I know sometimes, like, someone has suggested that I do a call-in show where people can call in and we can basically do a live consultation. I'll think about that. I haven't I haven't decided on that yet, but if people are interested in that, just let me know. I may um that may be something to explore in the future. But someone did, actually, a few people did suggest doing like a call-in show where we can do like an actual consultation online. We'll talk about it. um, oh, thanks for letting me know. So if I need anything served in Atlanta, I know who to reach out to. Nice. I like the connections, people. I like the connections. So, please ask me questions. Like I said, if you're watching this on the replay, put your questions in the comments. I will go back and respond to you. And thank you all so much for joining me. And as always, if you need to figure out your specific immigration journey, where you need to go, what's going on, and you want to have a more detailed conversation with me, and not just the general information that I give here, but really talk about your particular issues, your particular situation, you can do that by going to my website, lilylegal.com, and clicking on contact us and schedule your strategy session with me, or you can call my office at 508-443-1788. Thank you all so much for joining me again. And like I said, I am here almost every Friday. I do take some time off once a month or so. For May, we are doing, so next week we are doing the immigration news. The last Friday of the month, we are doing the Q&A session, which is what you are here for. And then one of those is going to be, one of the middle ones is going to be a teaching one. I may take the 17th off, for my birthday, but I'll let you know sooner to the date. Okay. So thank you all so much for joining me. Truly appreciate it. And remember, if you're watching this, where you can hit the like button, go ahead and hit the like button. And if you're watching it where you can subscribe, don't forget to subscribe. Thank you all so much. And I hope you have a great rest of your Friday and a great and wonderful weekend.